Hello, everyone. This is Will Trachman, one of the chairs of the Colorado Federalist Society. Ruben Nasrallah and Joe Peters, my co-chairs, are on the line today, although you can't see them on the screen. I want to thank everyone in our membership and in the crowd and in our C-SPAN audience for coming to today's wonderful presentation. This is one of our flagship events of the year, and it's an honor to have such a distinguished opening speaker, moderator, and panel to talk through the issues of the 2019 Supreme Court term with you. I'm going to introduce our opening speaker, and then we will go ahead and turn it over to our moderator, Shoshana Weissmann, who will then throw things off with the panel. So we're looking forward to an interesting discussion today with a lot of divergent opinions, and we are accepting questions in the Q&A box. So if you have a question, you can go ahead and open that box, submit that question. It can be at any time. It doesn't have to be at the end of the event. And we're looking forward to having a good number of questions as well as part. So with that, let me go ahead and introduce our opening speaker, Assistant Attorney General Beth Williams. Assistant Attorney General Williams was confirmed by the United States Senate unanimously on August 21st, 2017. She serves as the primary policy advisor to the Attorney General and the Deputy Attorney General, and as the Chief Regulatory Officer for the department. Ms. Williams graduated from Harvard College, magna cum laude, with a degree in history and literature. She earned her law degree from Harvard Law School, where she served as executive editor of the Harvard Journal of Law and Public Policy. After graduation, she served as a law clerk to Judge Richard C. Wesley of the United States Court of Appeals for the Second Circuit. From 2005 to 2006, Ms. Williams served as special counsel to the United States Senate Committee on the Judiciary, where she assisted with the confirmation of Chief Justice John G. Roberts, Jr. and Associate Justice Samuel Alito, Jr. to the United States Supreme Court. Prior to becoming Assistant Attorney General, Ms. Williams was a litigation and appellate partner at a national law firm, where her practice focused on complex commercial, securities, and First Amendment litigation. Ms. Williams litigated cases in federal and state courts across the country. She also served as chair of the firm's Women's Leadership Initiative in Washington, D.C., and she received the firm's Pro Bono Award 7 years in a row for her dedication to pro bono work. With that, I'm going to turn it over to our opening speaker, Assistant Attorney General Beth Williams.
Well, thanks so much, Will. Thank you for that kind introduction and for the invitation to join you today. Though I wish I could join you all in person, even at this great distance, it's a real pleasure to be here with you all, so thank you. For the past 3 years, I've been blessed to serve in what I believe to be one of the best jobs in the federal government, leading the Office of Legal Policy. At OLP, we serve as policy advisors to the Attorney General and to the Deputy Attorney General, and as many of you know, we participate in the selection, vetting, and preparation of all nominees to Article III courts. That mission affords a unique opportunity to evaluate where we are and how far we've come. In a moment, our panelists will share their insights into the most notable of the 63 decisions the Supreme Court issued this term. But first, it's important to put that number in perspective. In 2018, there were more than 358,000 cases filed in federal district courts across the country, and only 76 decided by the Supreme Court. What that means is that for every Supreme Court opinion that year, there were literally thousands of cases resolved by district court judges and courts of appeal judges across the country. That is why, from the Supreme Court to the district courts, the composition of the federal judiciary has a profound impact every day in every state in America, and will continue to have an impact for generations to come. Since the day that President Trump took office, this administration has been focusing on identifying and confirming strong constitutionalist judges. This, of course, could not have been accomplished without the incredible support of Leader McConnell and Chairman Grassley and Graham, who have prioritized judicial appointments. In the past 3.5 years, President Trump has nominated, and the Senate has confirmed, 2 Supreme Court justices, 53 Court of Appeals judges, 147 district court judges, and 2 Court of International Trade judges, not to mention the other judges who sit on various specialty federal courts. Those numbers, of course, include Colorado's very own Justice Neil Gorsuch and Judges Allison Ide of the 10th Circuit and Dan Domenico of the District of Colorado. All told, after just 3.5 years, there are more judges on the federal bench today appointed by President Trump than any other president except for President Obama. Even more extraordinary, right now today at 52, and with one more judge being sworn in next month, There are more active judges on the courts of appeals appointed by President Trump than any other president. And for the first time in at least 40 years, there is not a single unfilled vacancy on the nation's courts of appeals. And yet this incredible pace has not come at the expense of finding highly qualified candidates. The president's nominees are, and in fact, historically well qualified. According to many objective measures, and according to the American Bar Association, which Senate Democrats have described as the gold standard by which judicial candidates are judged, President Trump's judicial appointments are among the most qualified in history. Some, of course, question the ABA's gold standard honorific. Peer-reviewed studies have shown that the ABA evaluates nominees of Republican presidents more harshly than those of Democratic presidents. One study found that even controlling for credentials, Clinton nominees had 9.7 to 15.9 times as high odds of getting a unanimous, well-qualified ABA rating as similarly credentialed Bush appointees. That study concluded that just being nominated by a Democrat rather than a Republican was better than any other credential or than all other credentials put together. It is therefore all the more extraordinary that the judicial appointees over the past 3.5 years have earned the ABA's well-qualified rating at the highest rate in 5 decades. A remarkable 69.4% of President Trump's Article III judicial appointees have earned the ABA's well-qualified rating. Since the Ford administration, only President George W. Bush came close to matching that level with 69.3%. These accolades should be expected, and other measures tell the same story. From Supreme Court and appellate clerkships to prior service as a state or federal judge or prosecutor, these judicial nominees combine sterling credentials with deep and meaningful accomplishment. One liberal commentator acknowledged that based solely on objective legal credentials, the average Trump appointee has a far more impressive resume than any past president's nominees. We know, of course, that these judges are more than their resumes. They have lived lives of character, service, and patriotism, and have chosen to serve their country for a lifetime. Meeting these remarkable men and women, working with them, preparing them for their hearings, and seeing them confirmed to the bench is a highlight of my job. They're some of the very best of our profession. And I'm proud to report that there are more judges on the way. With 24 nominees currently awaiting confirmation on the Senate floor, and more still working their way through the Judiciary Committee, we are working to fill every vacancy we possibly can in the time that we are blessed to have. While we celebrate these confirmations, and rightfully so, given the unprecedented obstruction even of nominees with broad bipartisan support, let there be no misunderstanding that these judges are political actors. They are not. Consistently, our nominees are faced with a barely veiled, unrestrained cynicism that they can judge according to the law. They are derided for pledging to judge neutrally, as if that is either impossible or they are incapable. But neither is true. What I have seen over and over is that these judges sincerely believe in the foundational principle that their personal beliefs should play no role in their decisions. They adhere to a limiting judicial philosophy that guides their interpretation of the law in a way that makes it both consistent and most compatible with representative democracy. These are not platitudes, and they are expectations that are essential for our republic to function. And if, as a profession and a society, we cast aside those fundamental expectations in favor of cynicism and political power, we risk losing confidence in the institution that is meant to serve as our last protection from tyranny. Of course, no one is perfect, and judges are human and fallible. But if we have found, as I believe we have, brave, smart, and principled people who believe that there is a right answer and who strive every day to find it, not create it, then we have done our job. Thank you very much for having me, and I look forward to hearing from this impressive panel.
Thank you so much, Assistant Attorney General Williams. Those were terrific remarks. From there, I'm going to turn it over to our moderator for today's panel, Shoshana Weissmann, to introduce herself and as well our panelists.
Hi, everyone. Thank you so much for having me. I'm Shoshana Weissmann. I'm the head of digital media at the R Street Institute, and I'm also a policy fellow there, focusing largely on occupational licensing reform, certain regulatory issues. kind of regulatory issues across the board, and sometimes Supreme Court things. It's a real honor to be able to speak with you all today, especially because I've been involved with the Federalist Society since I was 16. I'm one of very few who can say that. I'm a giant nerd, but it's a fantastic organization. And I've just always loved the ability to participate as a viewer with an organization that would just have honest and intellectual debate. One other thing I would like to note, during and after the speakers talk about their cases, you can, as mentioned, you can submit your questions through the Q&A function, but if you have a question for a particular speaker, it's always worth noting so I know who to address it to just in case. So now I'd like to introduce our esteemed panel. Josh Hammer is Newsweek opinion editor, a syndicated columnist, and of counsel with First Liberty Institute. A graduate of Duke University and the University of Chicago Law School, Josh has worked at Kirkland & Ellis LLP and clerked for Judge James C. Ho of the U.S. Court of Appeals for the Fifth Circuit. A former John Marshall Fellow with the Claremont Institute, Josh is also a law school campus speaker through the Federalist Society and a college campus speaker through the Young America's Foundation. Samantha Harris is a senior fellow at the Foundation for Individual Rights in Education and an attorney in private practice with a focus on free speech, academic freedom, and due process cases. She is a graduate of Princeton University and the University of Pennsylvania Law School, and she clerked for the late Judge J.C. Waldman of the U.S. District Court for the Eastern District of Pennsylvania. Professor Alan Chen is a professor of law at the University of Denver Sturm College of Law and a leading expert on free speech doctrine and theory, the law of federal courts, and public interest law. He is the co-author of 2 books, Public Interest Lawyering, A Contemporary Perspective and Free Speech Beyond Words, The Surprising Reach of the First Amendment, as well as numerous scholarly articles. Although he's a full-time academic, Professor Chen continues to carry an active litigation docket and represents plaintiffs in many high-profile civil rights cases in federal courts around the country. Prior to joining the faculty, Chen was a staff attorney with the ACLU's Chicago office and a law clerk to a federal district court judge in Illinois. So to begin, because there was so much interest in the case, I would like to begin by having Samantha Harris discuss Bostock v. Clayton County, Georgia, and then we'll have the other panelists join in and weigh in on it. But we'll start there. So off to you, Samantha.
Thank you, Shoshana. And like you, I'm really honored to be here. Federalist Society is just such a great organization, and I always love participating in your events. So this case obviously is the case that held that an employer who terminates an employee for being gay or transgender violates Title VII. This was a 6-3 opinion authored by Justice Gorsuch, with the majority joined by Roberts, Breyer, Ginsburg, Sotomayor, and Kagan. And I'm just going to say a few things about it and then let my co-panelists chime in as well. I think I personally would distinguish here between the views of Justice Gorsuch, who wrote the majority opinion, and who seems to be developing his own sort of results be damned doctrine of what Josh Blackman calls halfway textualism. And what I look at is a more results-oriented decision of obviously the 4 liberal justices, but I also suspect Justice Roberts. I mean, I suspect that those 5 justices, or at a bare minimum, the 4 liberal justices, would have reached their desired result regardless of the reasoning of this case. So to the extent that that played a big role, I think that this is the kind of results-oriented adjudication that, I think has sort of really distorted the whole confirmation and even political process by allowing the court to function as sort of an unelected super legislature. But moving on, for me, I think the most interesting debate, kind of as a linguistics nerd, came down to Justice Gorsuch v. Kavanaugh on this idea of ordinary meaning versus literal meaning. A lot of the result of this case came down to what the phrase discriminate against but because of means. And I actually found both justices' arguments persuasive at times. I mean, I guess that's the thing about, these great writers. You're reading and you're like, oh, yeah, that makes a lot of sense. And then you read the next thing and you're like, wait, that makes a lot of sense too. Although I ultimately think I side with Kavanaugh, despite, personally supporting the policy outcome of ending sexual orientation discrimination. So, Justice Gorsuch relied on what he called literal meaning, and he found the plain text of Title VII to encompass sexual orientation and gender identity discrimination by breaking the phrase discriminate against because of into two clauses. So the because of clause, he reasoned, creates a but-for causation test that allows the court to conclude that an employer who fires a man for being married to a man when he would not fire a woman for being married to a man has engaged in prohibited discrimination because the result would have been different, quote, but for the employee's sex. And this is where Kavanaugh really disagreed and insisted that you had to focus more on ordinary meaning than literal meaning, and that this means, among other things, considering the meaning of phrases as a whole and not just looking at their component parts. So, for example, he noted that, an American flag could literally encompass any flag that was made in America, but in common parlance, it denotes the stars and stripes. And so along the same lines, discriminate against because of, according to that reason, has to be read together, and in that way would be understood to mean that there must be some sort of sex-based bias or prejudice, which isn't at issue in cases of discrimination based on sexual orientation or gender. So for me, that was kind of the most interesting debate. I think I come down on the side of Justice Kavanaugh, that you don't break this phrase into two parts and use this but-for causation test, but that you have to kind of look at what it actually means to discriminate against someone on the basis of sex. And, again, I support ending discrimination on the basis of sexual orientation and gender identity. Congress has obviously tried to do it many times and failed, and that's something the court pointed out. And I suspect that they just sort of ended up circumventing Congress here for policy reasons, but that's not, the direction we want to see the court go in. So I have tried to keep that relatively brief because I know that my other panelists want to say things about it too. So I will just pause here for the moment.
Josh or Alan, would you like to weigh in?
You go ahead, Josh.
So thank you, Colorado Federalist Society, for hosting this wonderful panel. I actually just moved to Denver literally at the end of last week over the weekend, so I will miss the great state of Texas dearly, but I'm happy to be exploring the Rocky Mountains region with hopefully many of the people viewing and tuning in here. So thanks for having me. Thanks to Beth Williams for those wonderful remarks, and this is a great panel and a great discussion. So I hate to kind of be the voice of dour pessimism, but I'm pretty sure that's why I was brought into this panel in the first instance. So I'm just going to do what I generally do and kind of come in two guns blazing. Bostock is an utterly farcical ruling. It is completely unsupported by any rudimentary understanding of the classical legal tradition. It is completely counter to any notion of textualism, originalism that is predominating in the legal academy and legal discourse for 3 to 4 decades. And I think that Senator Josh Hawley is completely right to characterize this ruling as a crisis level moment for the legal conservative movement, which is what he did in a floor speech the day after the Bostock ruling. Now, as I think Samantha quite correctly pointed out, the key phrase here, of course, is discriminate against because of sex. The problem is that even going back to when Ruth Bader Ginsburg was an ACLU attorney back in the 1970s, even she argued persuasively, I think, that the key issue in that phrase, in the meaning of Title VII, is whether one sex is disadvantageously positioned relative to the other sex. Now, if you go back again to classical legal theory, going back at least hundreds of years to Aquinas, Maimonides, I would argue going back thousands of years to Plato, Aristotle, Cicero, and all the great ancients, it has always been understood in the common law tradition, in our tradition, in every tradition conceivable that we might have possibly inherited into our broader discourse, that the common usage and common meaning of a term at the time of enactment is pivotal. And in interpreting a phrase, interpreting a word, you cannot divorce either the common usage or the common meaning of a term at the time that the provision was enacted, or the overarching purpose or goal of what the legislators had in mind. This is not to get into the legislative intent debate, which of course, the late Justice Scalia wrote against, I think, quite persuasively, including, of course, in 1997, The Matter of Interpretation. This is not about legislative intent. You're not trying to divine the intentions of an individual legislator or a collective legislative body. Rather, the overarching purpose of what the legislative body had in mind when they sat down to hash this out simply must imbue the judicial enterprise of reading these statutes. Now, I think that the consequences of Bostock are potentially disastrous for religious liberty. We've already seen some litigation. There's a Catholic hospital that's facing a lawsuit immediately where the plaintiffs are pleading Bostock. I will return to this in my comments further down the road, but I think what Justice Gorsuch is doing, Josh Blackman calls it halfway textualism. I think that's fine. I would call it robot textualism. It is a textualism completely untethered to anything that remotely resembled the meaning of the phrase at the time it was enacted. We can call it literalism too, as a literalist textualist distinction perhaps. But even Scalia, who again was quite critical of congressional intent, and I think he was accurate in doing so, he was justified in doing so, Scalia himself said over and over and over again that textualism is not literalism. And that is what Gorsuch has done here. I think he does it again in Mcgirt versus Oklahoma, but I'll hold off on that until later in the panel.
Not surprised. Well, first of all, thank you for inviting me to this panel. As you might guess, I am not a member of the Federalist Society, and I am here to offer a slightly different perspective from some of the other panelists, although I imagine we'll have some substantial agreement on some things as well. So my comments on Bostock, I don't think it's a travesty. I do think there's some difficult methodological issues about statutory interpretation at issue in the case. But I actually don't think that there's a specific ideological valence to the way that Justice Gorsuch carried out his analysis, which you can reasonably disagree with the way, I agree with Josh, that you can reasonably disagree with the way he engaged in the text, in what I would call textualist formalism, really. The reason I say there's no specific ideological valence here is I can just imagine many cases in which this specific textual analysis is going to benefit the conservatives. And I think that Justice Gorsuch has the long game in mind, and that there will be other cases in the future applying this particular analysis, in which you members of the Federalist Society might find the results a little bit more palatable. I do think there's an interesting question about original public meaning or original plain meaning versus textualism in this case, because these are typically both devices that conservative judges have employed at different times. As I mainly focus on constitutional interpretation. Textualism and original public meaning are both different forms of originalism, although not, as Josh points out, the way that Justice Gorsuch probably applied it here. I think everybody is in agreement that Congress in 1964 was not thinking about sexual orientation or transgender discrimination when it drafted the statute. In fact, there's all sorts of interesting history about the negotiation about adding the gender provision in Title VII to begin with. I also think that Josh is wrong about religious liberty. I think this court has shown a penchant for robustly protecting the claims of people for religious exemptions from generally applicable laws. We see that even in some of the cases that I think Samantha will be talking about later. I think what's really interesting is that I think this case and some of the other decisions are on a collision course with Employment Division versus Smith, which some of the justices have suggested maybe should no longer be good law. And for those of you who are familiar with it, Smith is basically a claim, a decision by the Supreme Court and by Justice Scalia that says that when anybody that denies basically claims of religious exemption from generally applicable laws as violations of the Free Exercise Clause. Now, obviously, this is a federal law, not a state law, and so the other question is, will similar challenges be brought in other states under RFRA to sort of claim exemptions from a generally applicable federal law? So I foresee this being a positive decision for the left for a short while, and that there will be the next. You put this in the same category as Masterpiece Cake Shop. That there's going to be another case that raises specifically the religious exemption claims that the court has seemed to be, at least in this current generation, very accepting of.
I'd like to thank the panelists for their poignant and brief comments too. You all got in quite a bit in very little time, which I appreciate. And this leads us next to Professor Chen. I'd love for you to go on and discuss the other cases that you have for this panel.
Sure, thank you. So I have a fairly unenviable task of talking about a lot of cases in a short amount of time, so I'm going to do my best. What I would say generally is, and this actually goes back to the Bostock decision, the cases that I'm going to talk about for the most part, except for the Faithless Elector decision, are really just all different forms of separation of powers battles. You can even conceptualize Bostock as a separation of powers case, not a statutory interpretation case, because the question here is whether the court exercised its power in a way that interferes with Congress's authority to say what the law is or to make the laws. And that's what the dissenters sort of criticized Justice Gorsuch's majority for doing, which is saying, hey, if Congress wants to amend the law, that's fine, but the court should not be in the business of doing so. And I think that you'll see that these same types of separation of powers considerations are at stake in just about all the cases I'm going to talk about. So I'm going to start with Hernandez versus Mesa, which is actually the second time this case has been brought before the Supreme Court. You may be familiar from the facts from reading the newspapers. This arises from the tragic cross-border shooting by a federal border guard of a 15-year-old Mexican citizen. The plaintiff claims that the young man was playing a game with his friends, jumping back and forth across a water culvert that was right at the border between Mexico and the United States, and sort of running over, tagging something, and then running back. The officer claims that there was some provocation on the kid's part while they were playing this game. In any event, the border guard shot and killed the 15-year-old Mexican boy, and the plaintiffs claimed that that was done without legal justification and sued the officer for damages for deprivation of constitutional rights under the Fourth and Fifth Amendments. The issue in this case involves whether there is an implied right of action or cause of action against federal officers for damages in cases where the officer is accused of violating a constitutional right. No statute authorizes such a damages suit against federal officials. Rather, that authority comes from a case called Bivens versus 6 unknown named federal agents, where the Supreme Court found an implied right of action to sue federal officers, in that case for a search that allegedly violated the plaintiff's Fourth Amendment rights because it was unjustified under the Fourth Amendment. The Supreme Court has recognized Bivens' claims in a couple of other contexts, but it has generally been reluctant to extend Bivens' actions to new claims. Bivens itself, in fact, asked the court to consider in evaluating whether there's an implied right of action against federal officers, whether to consider special factors that weigh against the recognition of an implied right, including whether there are alternative remedies or whether there are policy reasons for not recognizing that specific type of action. In a 5-4 decision written by Justice Alito, the Supreme Court in Hernandez versus Mesa held that there was no implied right of action for the suit against the federal officer for a couple of different reasons. First, the majority said the cross-border nature of the shooting meant that it was a new context for such suits, and that was something that the court had said in a prior decision. This should be a factor that weighs against the recognition of a new implied right to sue. Second, the court majority said allowing such claims against Border Patrol officers in this particular context could both undermine border security, which is sort of something that they were reluctant to have the courts interfering with, and could affect international relations. As you can imagine, this specific event was the subject of a great amount of diplomatic tension between the United States and Mexico. And in any event, the majority said that it should be deferential to Congress's role in sort of creating new causes of action and not recognize an implied cause. Justice Thomas, with Justice Gorsuch joining, wrote a separate concurrence calling for the overruling of the entire line of Bivens cases. In other words, rejecting at all the idea that there should be implied rights of actions against federal officers for constitutional violations. Justice Ginsburg and the three other progressives on the court dissented. Justice Ginsburg's opinion suggested that the context of this case, if you sort of boil it down to its basic facts, which is a wrongful shooting of a citizen in violation of the Fourth Amendment by a federal law enforcement officer, that's actually not that different from the facts of other types of individual damages claims, and that she just disputed the claim that it would disrupt either border security or international relations to recognize the cause of action in that case. The second case I'm going to talk about is Department of Homeland Security versus Regents of University of California, which is the Daca decision. But it's really not a Daca decision, it's an administrative law decision. And this is one where Justice Roberts, in addition to the Baca case, joined the liberals on the court to rule, and he writes the opinion in the ruling. The issue in this case is whether President Trump's order to repeal the Daca program violated the Administrative Procedures Act. Daca, as you all know, is a program initiated by the Obama administration through an executive order where the Department of Homeland Security was directed to allow a temporary deferral of immigration action against children who were brought to the United States at a young age and who had since sort of become embedded in American society through having graduated from college, having taken a job and paid taxes, were serving in the military, etc. But again, the case is not about the merits of the Daca case. The question is, did the Trump administration properly adhere to the technicalities of the Administrative Procedures Act in trying to rescind the Obama executive order? The Trump administration argued that Obama's executive order itself was a violation of administrative law or constitutional authority because it claimed that the federal immigration statutes did not delegate to the Department of Homeland Security the authority to defer for a wide range of people. Daca is reported to have affected about 700,000 to 800,000 people in the United States. That was not the type of executive discretion in terms of not prosecuting or enforcing law in a specific case, but was a broad policy decision that the Obama administration did not have the authority to engage in. And in fact, the Trump administration's argument for rescinding Daca was basically, well, it was illegal in the first place, and now we decided that it was illegal, and so we're going to rescind it. The legal issue in the case was whether, under the Administrative Procedures Act, the Trump administration had sort of gone through the appropriate procedural hoops under administrative law, and whether the DHS's decision violated the APA because it was, quote, arbitrary and capricious. The majority held that the Daca rescission was a violation of the APA and was an arbitrary and capricious decision that did not provide a sound or explanation for its decision to repeal the policy. As you might know from reading the papers about this, the repeal of Daca was basically went through a couple of short memorandum, one by Elaine Duke, who was the head of DHS, and then a subsequent one by Kirsten Nielsen, when she became the director of DHS later, that tried to expand upon the Trump administration's reasoning. Now, as I said, the case is not at all about the merits of Daca. Justice Roberts' opinion makes it clear that if the administration sort of went through the proper procedures under the Administrative Procedures Act, it would be of course, have the authority to rescind a prior president's executive order. You might sort of remember the census case from last term. There's a very similar kind of vibe in Justice Roberts' opinion. It's like, you can change the law whenever you want. You just have to cross your T's and dot your I's. Justice Sotomayor concurred, agreeing with the majority's APA analysis, but disagreeing with its rejection of a separate claim, which was that the rescission of Daca disproportionately affected people against people based on national origin, and therefore was a violation of the equal protection concepts under the Fifth Amendment. Justice Thomas wrote a dissent along with Justice Alito and Gorsuch, whose main argument was basically what the government had argued in this case, which is Daca was illegal in the first place. So the court ought to defer under the Administrative Procedure Act to its rescission, notwithstanding the fact that the explanation was not fully developed. The next cases I'm going to talk about are two cases, actually, which are the so-called financial subpoena cases, Trump versus Vance and Trump versus Mazars. As you all, I'm sure, know, there were two separate cases involving the power of, first, a state prosecutor, and second, of Congress to issue subpoenas to third parties to obtain copies of the president's financial records. The purpose of the grand jury subpoena in the New York case was to further a criminal investigation into aspects of President Trump's private business dealings that were sort of the subject of a criminal investigation initiated by the district attorney Cyrus Vance. The purpose of the congressional committee subpoenas, at least ostensibly, was related to the formulation of possible new legislation. For example, the possibility of enacting statutory provisions to prohibit certain types of conflicts of financial interest between the president's private dealings and the president's role as the president. The documents all that were sought were all involved President Trump's private financial documents, tax returns, and other things that were held by third parties. So they're not themselves, the documents were not subject to executive privilege per se. And again, the subpoena was directed at third parties, not the president. So there wasn't the same types of executive privilege claims that we've seen in other cases. In both cases, for different reasons, the Supreme Court upheld the validity of the subpoenas, but remanded them to the lower courts back for further consideration. Chief Justice Roberts wrote both of the decisions basically which were 7-2 against President Trump. In both cases, the Supreme Court rejected the President Trump's claim that he ought to enjoy blanket immunity, executive immunity from subpoenas in both the context of a state criminal investigation and in the context of a congressional subpoena. I'm relying on the decisions of the Supreme Court in the United States versus Nixon and Clinton versus Jones. The majority sort of noted that in prior cases where the president had sort of asserted executive privilege, the Supreme Court had been pretty clear about rejecting sort of blanket absolute immunity claims. That is, the claim that I am the president, therefore you can't subpoena me, as opposed to I am the president, subpoenaing this particular document is going to reveal national security secrets or undermine my ability to carry out my executive functions. And the court noted that both in Nixon and Clinton, the charges against the presidents in those cases were quite serious. Yet the Supreme Court rejected an absolute immunity claim. In the Vance case, the Supreme Court also rejected President Trump's claim that the prosecutors had to show a special need for the documents in order to enforce his criminal subpoena or grand jury subpoena. The majority noted that the president may make the same objections to subpoenas as any other private citizen. For example, claiming that the scope of the subpoena is overbroad and not directed only at the underlying criminal investigation. In Trump versus Mazars, the court held that while there's not a categorical heightened need standard for the Congress, the court rejected Congress's claim. The court rejected the president's claim that Congress had to show a special heightened need to enforce a subpoena against the president, even if it was pursuing a legitimate legislative objective. However, the court also rejected Congress's claim that when Congress subpoenas the president, the subpoena should be limited only in the same way as subpoenas for other private citizens would. The court recognized that if there were no limit on congressional subpoenas, Congress could exert control over the executive branch and engage in harassment for non-legitimate purposes, and that could happen no matter who's in charge. The majority then sort of adopted a 4-part balancing test to determine when and in what situations Congress had exceeded its power to enforce a subpoena against the President of the United States. How am I doing on time, Samantha? Shoshana.
I was going to say you have about 2 minutes left.
Okay, I'm going to skip over the dissents in Mazars and Vance, but we can come back and talk about them in the discussion if anybody wants to talk about them. The last case I'm here to discuss is that there are 2 cases, Colorado Department of State versus Baca and Chiafalo versus Washington. These are the so-called faithless elector cases. The question in the case is whether a state may punish or disqualify a duly elected elector who fails to vote for the presidential candidate who received the majority of the popular vote in that state, or whether electors once appointed, as the plaintiffs in these cases argued, had the right to exercise their discretion about who to vote for president of the United States. This is one of the rare unanimous decisions by the Supreme Court this term. Everybody was in agreement that under the Constitution, while there's no specific direction from Article 2 of the Constitution, which talks about the Electoral College, or from the 12th Amendment to the Constitution, which pairs presidential and vice presidential candidates, that neither of those provisions speak specifically to the question in this case, which is, can states punish or remove an elector who refuses to vote for the person who got the majority vote in the election? That it also, that the court said these provisions also give states the power to appoint electors, including what the process will involve. And the court concluded that includes imposing certain types of conditions, whether they're fines or actual sanctions by removing them from the process and having somebody else take their place. And so the court unanimously decides that the states, if they choose to, not all states do this, can impose sanctions on faithless electors. The only sort of other point I wanted to add is that Justice Thomas agreed with the outcome, but concurred on a separate, what I would call an idiosyncratic view, that the reason that states, that he agreed with the outcome, but he said the reason that the states had the power to sanction faithless electors is that because the Constitution does not give that power to the federal government, it must be reserved to the states under the 10th Amendment. So sort of pushing his argument about a more expansive, aggressive reading of the 10th Amendment's ability to limit federal power and to grant states power. Okay.
Thank you so much, Professor Chen. You got in quite a bit in such a little amount of time, and yet it was so comprehensive. Next, Samantha, I'd love for you to go over your cases.
Absolutely, yes. And I now have the same amount of time to cover 2 cases that Professor Chen had to cover 4 in. So I think that will leave some time, to go back and maybe discuss some of these cases, because I don't think it will take me the whole 15 minutes. So I am covering the 2 religious freedom cases, Espinoza v. Montana Department of Revenue, and the Little Sisters of the Poor case. Now, these were both religious freedom cases, but interestingly, they had some other things in common too. They both involved the dissent arguing that the court had sort of gone beyond the scope of its jurisdiction to address questions not before it. And that's a little bit of an interesting piece to these cases that I want to touch on. So Espinoza is a case that involved a tax credit program in Montana. It was a program that awards tax credits to people who donate to organizations that provide scholarships to private schools. Now, Montana has a no aid provision in its state constitution, barring any direct or indirect aid to sectarian schools. And this is actually what's known as a Blaine Amendment, which sort of goes back to the anti-Catholic prejudice from the 1800s, when sectarian was really a code word for Catholic. Now, the majority didn't address sort of the anti-Catholic origins of this provision in great detail, but Justice Alito did in his concurrence, and people who are sort of broadly opposed to these Blaine amendments viewed this decision as a big victory in that regard. So finding that the aid to religious schools, so obviously, most of Montana's private schools, as it turns out, are religious, are Christian schools. So, a lot of the people who were awarded these scholarships, including Kendra Espinoza, who used them to, I think she was a single mother, who using them to put her daughters through private school, used them at sectarian schools. So the Montana Supreme Court found that the fact that this tax credit program gave aid to religious schools as well as secular schools violated the no aid provision. And what the Montana Supreme Court did was to invalidate the entire program and eliminate scholarship support for both secular and religious schools. And this was sort of one of the major flashpoints in the decision between the majority and the dissenters. The question, nobody really disagreed that withholding aid from religious schools under a scholarship program that you're providing to secular schools would be a problem from a free exercise standpoint. But what the justices really disagreed on was whether the Montana Supreme Court's decision to invalidate the entire scholarship program remedied any free exercise violations stemming from the withholding of aid just to religious schools. Because clearly, Montana's state legislature would not have been obligated to create this tax credit program in the first place. But what the majority held, and this was a 5-4 decision that went straight along liberal conservative lines, what the majority held was that the Montana Supreme Court's decision to strike down the whole program was based on a flawed free exercise analysis, so that the outcome was sort of the fruit of the poisonous tree and couldn't be justified on neutral state law grounds. And the dissent, by contrast, argued that because the Montana Supreme Court had arrived at a solution that was constitutionally permissible, i.e. no scholarship money for any private schools, that the court had no business addressing the question of whether barring only religious schools from the scholarship program was a free exercise violation. The court also talked about the relationship between the free exercise and the establishment clauses. This particularly came up in Thomas and Gorsuch's concurrence, where they argued that the Supreme Court's establishment clause jurisprudence was really what sort of led to the faulty decision by the Montana Supreme Court here. They held that when a plaintiff brings a free exercise claim, the government may defend its law, as Montana did here, on the ground that the law's restrictions are required to prevent it from establishing religion. This understanding of the Establishment Clause is unmoored from the original meaning of the First Amendment. So there was that discussion. There was also a debate over which precedent was more applicable. The Trinity Lutheran case, which involved funding playground equipment for schools, or the case of Locke v. Davie, where the Supreme Court upheld Washington State's prohibition on using state scholarships to pursue devotional theology degrees. And the majority held that Trinity Lutheran was applicable, and that Davie was really based on two things. One, the fact that he was denied a scholarship specifically because of what he proposed to do, which was to use the funds to prepare for a ministry. And that apart from that narrow restriction, Washington's program allowed scholarships to be used at religious schools that incorporated religious instruction throughout their classes, just like the scholarship program in Montana. And Davie, the court held, also invoked a historic and substantial state interest in not funding the training of clergy. Breyer and Kagan, in dissent, held that Davie was felt that Davie was far more applicable than Trinity Lutheran. And then the other case I want to talk about is the Little Sisters of the Poor case. This was the case about the ACA's contraceptive mandate. This was a 7-2 decision with Justices Kagan and Breyer separately concurring in the judgment, and with Alito and Gorsuch writing a separate concurrence. At issue in this case was the government's efforts to comply with the Supreme Court's ruling in Zubik v. Burwell, which directed the government to accommodate those employers who felt that the self-certification exemption created by the Obama administration made them impermissibly complicit in the provision of contraception. So the self-certification exemption required non-church organizations who objected to the contraceptive mandate to submit paperwork certifying their objection, which would then trigger the provision of contraception to employees by other means. And so what organizations like Little Sisters of the Poor argued was that the self-certification exemption was not a sufficient accommodation because it still made them complicit in the provision of birth control. So, I mean, this was a religious freedom case in a lot of ways, and it did discuss RFRA. But I thought really fundamentally that it's a scope of agency discretion case, both in terms of how much authority an agency has in the absence of an explicit congressional limitation on that authority, and also in terms of how much an agency needs to sort of show its work, so to speak, in terms of incorporating feedback between the issuance of an interim and a final rule. And on both questions, the majority here came down in favor of agency discretion. Indeed, some of the amici in this case raised the issue of non-delegation, but the majority punted on that because no party had raised a constitutional challenge to the breadth of delegation. And this is where I was talking about, drawing the parallel with Espinoza, where, here the court said, well, we're not going to address that because, nobody has specifically raised it. But to some degree, they did that in Espinoza, going beyond the question before them to look at the Montana Supreme Court's free exercise analysis. So that's sort of an interesting little parallel between those cases, or maybe sort of a tension between them. Also at issue here was the scope of RFRA and whether it potentially applied to the petitioner's complicity argument, or whether that argument stretched the act beyond its intended scope. So the respondent states here argued that the government couldn't even consider RFRA in formulating the exemptions, and that was an argument that the majority rejected out of hand, but the majority did stop short of considering whether RFRA required the exemptions. And this was sort of controversial because, as Alito and Gorsuch noted in their concurrence, the respondent states were certain to argue in the lower courts that these exemptions were arbitrary and capricious. And the Kagan and Breyer concurrence gives the respondents a roadmap for doing just that. So Alito and Gorsuch would have had the court reach the RFRA question and hold that RFRA actually requires the exemptions. So that is my little brief on those two cases. And I think, I probably have a few minutes left over. So if someone else, I don't know if Alan had any points he didn't get to sneak in about his earlier cases, or if we just want to leave some more time for discussion at the end. But
thank you so much. Yeah, I was thinking we might have a little bit more time for discussion at the end, which will be perfect, especially because there's a lot to get to on all of these cases. Josh, would you like to go next?
Yeah, thank you. So I also only have two cases, so I presume I will also not take my full allotted time, and happy to leave any time left over for questions, interaction on the panel, basically however Shoshana wants to divide it. So my two cases are June Medical Services, which is the Louisiana abortion case, and Mcgirt versus Oklahoma, which is the Indian law case. I'm going to start with the latter because the former will more directly tie into some of my broader themes and judicial nominations and other topics that I kind of want to delve into in my fairly limited time. So in Mcgirt versus Oklahoma, a 5-4 majority, once again led by Justice Gorsuch, who even on the 10th Circuit here in Colorado had established himself, I think, as one of the friendliest federal appellate jurists to American Indian tribes. He reaffirmed the reputation. I don't really know how else to say it. In a landmark 5-4 decision, 43 to 44 pages, basically saying that the tribe of the Creeks in 1833, according to a treaty following the Trail of Tears in eastern Oklahoma, was never formally disestablished by the U.S. Congress. Chief Justice Roberts actually has a blistering dissent, very lengthy blistering dissent in this case, which is actually fairly rare for the chief. I think that's one thing that I found really interesting. I saw some graphic, I think it was either the New York Times or Vox had a graphic about this most recent term, the percentage of the time that a given justice was in the majority in a case. Clarence Thomas, despite this being the most purportedly conservative court, LOL, that we've heard in decades, Clarence Thomas was actually dissenting more often than any other justice. It was actually the chief who was in the majority most of the time. And I think, we can all speculate about what actually motivates the chief. I think it's, at this point, fairly well accepted that he might have some non-textual concerns, shall we say, about the institutional integrity of the court and things of that nature. So he, unsurprisingly, is in the majority most of the time. And this is actually a trend that's happened multiple years now. So when the chief dissents, let alone a 30 to 40 page dissent, similar to what he did, of course, in Obergefell, where he was the main dissenter, I think we ought to pay very careful attention to that. So the main disagreement in Mcgirt, which again I feel I need to emphasize, overturned a conviction of a man who was convicted for molesting, forcibly raping, and sodomizing a 4-year-old girl. What the court did was it basically said that Congress never formally disestablished the treaty that it enacted with the Creek Nation in 1833. The source of legal tension here amounts, again, to tie it back to what I was talking about in Bostock earlier, to whether we are going to engage in a truly textualist, I might call it robotic textualist or literalist, reading as to whether Congress has truly, explicitly, in no uncertain terms said that we are disestablishing this tribe, or whether using the court's well-established century-old precedent in the area of American Indian law, whether we follow what I think Chief Justice Roberts basically says is kind of an all of the above test. And in the Chief's dissent, he basically says that if you look at various idiosyncratic congressional actions all throughout the 19th century, building up until Oklahoma's admission to statehood, and I think it was 1907 or 1908, Congress also set up a commission with respect to trying to delegate jurisdiction to Oklahoma away from the tribes. The chief basically says that this all of the above test served to disestablish the 1833 treaty. Gorsuch disagrees, using his textualism approach. The problem, which our friend Josh Blackman wrote about in an Atlantic essay a couple of weeks ago, is that I think Justice Gorsuch is trying to have it both ways. On the one hand, he is professing to be a true textualist. On the other hand, he never makes any direct paeans or appeals to stare decisis. He doesn't really engage in the actual intellectual gritty work that I think would be required to try and reconcile textualism precedent and what is in the area of American Indian law, similar to antitrust law. I think what the court has established is a generally common law-esque approach where it is well accepted that we do not engage in a textualist framework. Nonetheless, the consequences of Mcgirt are potentially fairly dire. 19 million acres of the largely eastern half of the state of Oklahoma we are told, is now no longer part of Oklahoma. Congress, can obviously take action to remedy this and formally disestablish. They can do the precise textual language that Justice Gorsuch is looking for anytime they want. I guess they're too preoccupied with whatever it is that they are purporting to do these days. That is the obvious consequence of Mcgirt. The chief talks about some of the more concrete, tangible potential applications is everything from zoning law to family law. I mean, the city of Tulsa, the second biggest city in the state, is actually encompassed in these 19 million acres. So I have not been personally to Tulsa since Mcgirt was handed down. I presume it's not quite the wild, wild west and the gunfight at the OK Corral, but there's certainly some legal uncertainty there on the ground. Turning to June Medical Services. Again, this is a 5-4 decision. And the law that we are referring to here, which comes out of Louisiana, and actually the Fifth Circuit had upheld this regulation. The regulation, which was enacted by the Louisiana State Legislature, requires that abortionists and abortion clinics have hospital admitting privileges within 30 miles of where the clinic is located. Now, court watchers, astute observers, pro-life litigants, pro-lifers in general might recall that this is a virtually identical law to a somewhat infamous Texas law, actually. If you political junkies that are tuning in may recall, this was actually the law that pink shoe-clad Wendy Davis famously filibustered late into the night in May or June, I think it was, 2013, ultimately leading to the 2016 Hold Women's Health versus Hellerstedt litigation at the Supreme Court, where the court at that time, in a 5-3 opinion, because Justice Scalia had passed away just a few months prior, invalidated this Texas law. What's interesting, of course, is that Chief Justice Roberts dissented in Hold Women's Health. However, 4 years later, in June Medical Services, he concurs in the judgment. So, I tend to agree with Samantha, who earlier, while talking about Bostock, I think quite accurately referred to the 4 liberal-leaning justices as essentially being outcome-oriented in true culture war cases of this nature. I think that's pretty clearly what happened in the 4-justice plurality in June Medical Services as well. That is my read, my candid read on the situation. And I think what's interesting, of course, though, is even taking them on their word. And what they purport to be doing is applying the undue burden standard that the court, of course, fabricated in the 1992 case of Casey versus Planned Parenthood. If you actually look into the text of Casey, the language of Casey actually purported to allow the states to have a lot of discretion in terms of regulating and protecting fetal life. It's interesting to me how in Hellerstedt and now June Medical, the majority opinions do not particularly grapple with what I think is a fairly plain reading of the balancing of interests between the substantive due process, quote unquote, right to abortion and the state's interest in regulating and protecting fetal life. I don't think either Hellerstedt or June Medical particularly does a good job of doing so. But what I think is more interesting for our purposes, especially given this is a Federalist Society discussion, is to focus on the Chief's concurrence. So again, the Chief dissented in Home Women's Health versus Hellerstedt. He flip-flops here, even though he claims that he continues to believe that Hellerstedt was wrongly decided. But in his concurring opinion, he does so for one reason and one reason only, of course, which is an appeal to stare decisis. This is about as rigid and wooden a view of stare decisis as I think I have ever seen in a Supreme Court opinion. It frankly is astonishing. Now, the Chief has the temerity, I would say, to quote Edmund Burke's Reflections on the Revolution in France to support this invocation of stare decisis. I am a proud Burkean. I love Reflections on the Revolution in France. What I think the Chief misses is that Burke was not writing about jurisprudence. He was writing about abstract rationalism in political revolutions. In fact, my friend Jeremy Rosansky actually has a forthcoming essay on Burke's jurisprudence, and suffice to say, it is not consonant with how the Chief invokes it. But what the Chief, again, is doing here, if I can just kind of more extrapolate and just talk about it in kind of broader strokes here, I think he obviously is concerned with the so-called institutional integrity of the court, especially in an election year. And, look, I'm not going to be all dour here. I am happy to concede that there were some legitimate, quote-unquote, wins from a conservative perspective this past term. I think Espinoza is a brilliant example. Espinoza is a great victory. Blaine amendments were insidious at the day that they were all enacted, and it is fantastic to see the court beginning to overturn this. And then kind of returning to something that Alan said about Bostock, I actually agree that this court has shown time and time again a willingness to protect religious liberty. No doubt about that. Putting on my First Liberty Institute hat just for a moment, I think we at First Liberty are very proud to be a part of that project. The Bladensburg Cross case from last term was our case, and that's obviously true. At the same time, this is a point I think missed by David French, who's written about Bostock in these cases repeatedly. I think a point that a lot of these commentators, I think, miss is that the uncertainty of litigation itself is a cost to religious liberty. So that was just one point that I would emphasize, that there is uncertainty here. We are relying on what I agree would ultimately, after litigation trickles, be a favorable outcome. But that is a cost, that's an intrinsic cost in and of itself. But sorry, I'm kind of rambling here, but just taking it real back to June Medical Services and stare decisis just for a minute here. What I have an essay in next month's National Affairs about the stare decisis issue. And again, I mentioned the day after Bostock how Josh Hawley, the senator from Missouri, took the Senate floor to criticize it. And then in a follow-up speech, he actually articulated what is essentially a Roe versus Wade litmus test for new jurists that will come through the Judiciary Committee ultimately to get to the High Court. I think that is necessary, but actually not sufficient. I would actually proffer that we actually need an express stare decisis litmus test as well, because the problem is, even a justice as conservative and we believe to be jurisprudentially pro-life as Sam Alito, who I'm a huge fan of, to be clear, has had multiple opportunities in Hellerstedt and June Medical to sign on to a Clarence Thomas writing that explicitly calls to overturn Roe and Casey, and he has not done so. So from my perspective, actually, even though June Medical was a 5-4 decision with the Chiefs, risable, farcical concurrence again, from my perspective, from a pro-life perspective, it was actually an 8-1 loss. So I think that that this is a serious, pivotal crisis moment for social conservatives, cultural conservatives, pro-lifers. We are fighting serious cultural uphill battles. I think we are fighting jurisprudential and theoretical uphill battles, possibly even within the confines of our own legal conservative movement. There obviously are victories from this past term. Again, Espinoza is a great one. I think Chiafalo obviously comes out the correct way, but overall, I again hate to play this role, which I find myself playing all too frequently, but I think that there is a lot of cause for concern about where we're heading as a movement.
No, thank you, Josh, for being able to wrap that up and to tie so many themes in, especially with stare decisis, which I think a lot of people are starting to view in a different lens in a lot of different ways. Every time a new justice is confirmed, they're always asked, oh, will you uphold it? And then no one ever does all the time, because that's just not how it works. But I'm glad that's a theme you tied in, because I think that's been especially relevant. I'd like to take the moderator's privilege and ask the first question. I think a lot of times people view justices appointed by the same president in a similar light, and sometimes justified, sometimes not. Kavanaugh and Gorsuch, they're very different judges in some really unique ways. I personally was really interested to see Gorsuch during his confirmation hearings kind of give hints that he'd be more open to protecting unenumerated rights, which is one of my pet issues. But both of them are pretty unique jurists. But I'd like to hear from any panelists interested in weighing in how they view the Trump era of judges. And also feel free to get outside just Kavanaugh and Gorsuch and to go to lower court judges. But I think that the two of them can also paint a really interesting picture alone.
Well, I'll sort of say one broad thing that had sort of been on my list of things to talk about at the start, which is I think, to me, the two Trump justices follow a pattern that I see in other, Republican appointed justices and judges, which is, I just, and I don't want to see this. I don't want this to be there, but I continually see, more sort of what I would think of sort of intellectual and judicial honesty among the Republican appointed judges, in the sense that they all seem willing to sign on to opinions that they disagree with the policy outcome of, in keeping with their judicial philosophy. Whereas, in all of the cases that we talked about today, the liberal justices more or less voted in lockstep. And I don't want that to be the case. I find it incredibly frustrating because I don't understand why everyone wouldn't want justices who, want to be faithful to the law and to the Constitution. But so I think in that regard, broadly speaking, and then I'll let others get into the more granular discussion of the justices' philosophies themselves, because as I said, that's a little bit outside of my wheelhouse. But, I think broadly speaking, I see sort of the trend continuing of, the conservative appointed justices just being much more independent.
I'll weigh in a little bit. I think there is not infrequently, and this is true on the left and the right, for judges and justices to have different judicial philosophies than their political philosophies, and I don't think they're necessarily coextensive. So you can have a progressive justice or judge who's a little bit more less interventionist, and you can have I think conservative justices or judges who maybe take a judicially conservative approach, which is what you might describe Roberts, for example, as in his sort of minimalist institutional protecting role as kind of a judicial conservative, but they don't always match up. So second, I would say the other thing is that it's very early in Kavanaugh and Gorsuch's careers, and I don't think we've seen them develop yet. And part of the first few years of a justice's career are sort of carving out a niche for themselves. But who are they going to be on this court? What's their role going to be? And I don't think either of them yet know that. And it's not specific to them. I think it's a big difference to serve on the Supreme Court than the Federal Court of Appeals. And so I think they're figuring that out in real time, and we're watching that develop. But I think it's too early to make really strong predictions about that. Just quickly to rebut Samantha. So Kagan dissented in, I think it was Ramos versus Louisiana, the unanimous jury verdict decision. So she voted against what would be the more liberal result, I think, on the grounds of stare decisis. And so I don't think the conservatives have a monopoly on principled decision making or on sort of making decisions that might go against their political predilections in order to achieve different sort of institutional goals. Now, people speculate that Kagan did that because the precedent she's thinking about is Roe versus Wade. And so she wanted to sort of stake out her ground on establishing a strong sort of deference to stare decisis where possible. The other thing is, Roberts didn't care about stare decisis when he wrote Janus a couple of years ago. So I'm a little bit skeptical that justices on either side can be completely principled, to tell you the truth. I think there's outcome-oriented voting and sort of long view versus short versus specific outcome going on both the left and the right. And I think it's a little unfair to say that the progressive justices or the liberal justices are only the ones who do that.
So I guess if I can just kind of briefly rebut that and echo what Samantha said, the problem for the legal conservative movement is that for 25 to 30, 35, perhaps even years now, there was a repeated pattern of the liberal justices voting in lockstep on every issue of the day. Every so often, on the current court, Breyer and Kagan separated. We saw that in the Bladensburg Cross case. We saw that in Espinoza, right? Every so often, we get in the masterpiece Cake Shop. There admittedly are some cases where Sotomayor and Ginsburg go ahead and do their own thing. But as a general pattern, over and over and over again, all it takes is one justice to defect, and the conservative side tends to lose. And this kind of gets to a broader theme, which has been the subject of a lot of my recent writing, and I'm only going to continue to, I think, write about more of this, which is what exactly are we in the Federalist Society, we lawyers, we constitutionalists, we Americanists, frankly, what exactly are we fighting for? You know, I saw so many response pieces to cases like, really Bostock in particular, but a couple other pieces, so basically saying the following lines, like, you know, like we're all textualists now, right? I mean, we're disagreeing about how to apply textualism. It takes us back, of course, to Elena Kagan's confirmation hearing, where she says, we're all originalists now. Look, our Constitution is a beautiful document. It is not, contra to a lot of rhetoric, purely a intellectual descendant of Enlightenment theory. It was imbued by Enlightenment theories, imbued by classical theory. It was imbued by Judeo-Christian morality. It's a really wonderful document. If you take the preamble at its word, it was implemented to have lofty ends that Aristotle and Plato would have been proud of, to establish justice, to provide for the common welfare, common defense, secure the blessings of liberty, etc. These are wonderful aims, and our Constitution is inherently beneficial and it ought to be defended. Having said that, I can only speak for myself on this, but when I joined the Federalist Society and the legal conservative movement, not quite as young as Shoshana, but you know, I guess right before I hopped as a 1L at the University of Chicago Law School, I was more concerned with what I think the founders of this organization were concerned about around the time that it was founded in 1982. Which was overturning the Warren Court excesses. Roe versus Wade, obviously, Griswold versus Connecticut, case like that were chief among them. You know, Ed Meese, Ronald Reagan's attorney general, was famously asked, he was asked repeatedly, if you could overturn one case, what would it be? He actually said Miranda versus Arizona, a case that never comes up whatsoever in any of these conversations anymore. So I really do feel like we have just been we have been progressively inching further away from what we were founded to do. I'm really not answering Shoshana's question though, so I'm going to get back to that right now. Gorsuch and Kavanaugh, I think, have staked out obviously very different profiles in their time on the court. Justice Gorsuch clearly has very strong libertarian tendencies. He had a concurrence in his first full term on the court in Sessions versus DiMaia in April 2018 case, where for the first time in the entire history of the United States of America, an immigration enforcement statute was invalidated and nullified on purported constitutionally void for vagueness grounds, which elicited a 35 to 40 page Clarence Thomas dissent. So he has shown his willingness time and time again to protect his notion of due process, individual liberty, even perhaps in the case of Mcgirt versus Oklahoma, oppressed minority interests in a way that other Republican nominees in the court are not necessarily as inclined to do. Justice Kavanaugh seems to have a more traditional capital R Republican mold, for lack of a better term. A friend of mine once referred to him as Karl Rove in a robe. I think that's probably basically accurate. But although to Kavanaugh's credit, he has come out swinging now in some of these culture war cases. He obviously went very hard on Bostock. I think it was a wonderful dissent he wrote in that case. But he does have some more milquetoast tendencies. And we mentioned Ramos versus Louisiana. In Justice Kavanaugh's separate writing in Ramos, he takes a very kind of middle of the road, traditional, from my perspective, not particularly exciting view of the doctrine of stare decisis. It's very much kind of, we generally adhere to our precedent, but that doesn't mean we always do. It kind of made me throw up my hands and say, what is this? Suffice to say, it was a very far cry from Justice Thomas's writing in Gamble versus the United States, where he most fully explicated his view last term in June 2019. So they're really kind of, Gorsuch and Kavanaugh, I think, are establishing very different profiles. I am much more, I will praise, believe it or not, some things here. I'm much happier about the lower courts. I think the lower court transformation is real. On a personal note, as Shoshana mentioned, I clerked for Judge Ho of the Fifth Circuit. I have seen that transformation before my own eyes. The en banc votes on contested cases, they really are getting closer to being correct in a lot of these circuits. So I do not discount the lower court transformation whatsoever. I am a little more suspicious than perhaps some of my Federalist Society brethren about the current direction of the high court, but the lower courts, I would say, are more unambiguously heading in the correct direction.
Thank you all. The next question is for Professor Chen. Someone submitted, would the Faithless Elector case have any presidential value or any effect on a challenge to the National Popular Vote Compact, assuming that someone eventually had the standing to challenge the compact?
That's a great and difficult question. So going back to the way that the Constitution writes about electors, one of the things that they said in Chiafalo was that states have an enormous amount of discretion in selection in defining the process for selecting electors. So you could read that. I mean, if you literally read that as complete discretion, then I assume that would mean a state could flip a coin to decide, or pick a name out of a hat to decide who the electors are going to vote for. I don't think anybody would think that's a good idea. But the National Popular Vote, Compact is a little bit different from that, right? So for those of you not familiar with it, it's the idea that that states don't have to. So right now we have this winner-take-all system where in every state, whoever wins the popular vote gets all the electoral votes for that state, with the exception of Maine and Nebraska, which sort of do this sort of divide up the electoral votes. But all the other 48 states is winner-take-all. The National Popular Vote idea was for some states to basically push back against the process of the Electoral College, which sometimes results in somebody not winning the popular vote but winning the Electoral College vote. And the idea is that each state could make its own determination to join a compact that it will allocate its electors to whoever wins the national popular vote. And that if a sufficient number of states do that could have a significant impact. I don't actually know what I think about the constitutionality of the National Popular Vote measure. I think it's an interesting and creative idea. But if you take Chiafalo, seriously or literally, then there is a great amount of discretion. So I think it sort of might fall in the middle. I also think there's a possibility that the court would find a challenge to the National Popular Vote Compact to be non-justiciable as a political question. So maybe we'll never get an answer to that, and we may never get enough states to adopt it anyway. So.
Thank you, Professor Chen. Before I ask if other people want to weigh in, one thing I do want to note is that Professor Chen just gave one of my favorite answers from a scholar, which is I don't know. I appreciate the intellectual humility. We can't all know, even in our own areas, the answer to every potential hypothetical question, but I just wanted to mention I really appreciate that. But Samantha or Josh, any interest in weighing in on the issue?
I also don't know. I think it is a fascinating question. My instinct with that, it probably would be upheld based on my reading of Chiafalo. The states here seem to have just an incredible amount of discretion, but that really is a best guess.
Yeah, I don't have anything additional to add here.
No worries. So one question that someone asked, and not to make this all about Gorsuch, although I do tend to do that, someone had asked how Basta can be reconciled with a republic if you can keep it. I'm not sure if everyone read the book. I liked it quite a bit, but I could see how some people might have trouble reconciling those two. So, or whoever would like to take it.
I'll hop in. That's fine. I think I answered to that interlocutor by basically just saying it can't be reconciled, which I think is basically right. Look, when we talk about lowercase r republicanism, we're obviously talking about Lockean Enlightenment notions of consent of the governed, of a self-governing people. The entire notion, and this is obviously a pet issue of mine that's a little beyond the scope of this particular discussion, but the entire notion of judicial supremacy, of 9 robed oracles in the high court, deigning to overrule we the people here in flyover country, is completely antithetical to overarching political notions that undergirded the American founding. And that particular doctrine of judicial supremacy kind of dates back to the 1958 case of Cooper versus Aaron, which is, again, a little beyond our scope here, but more generally, to kind of tie it into Bostock, we see, Samantha mentioned this, Congress repeatedly has tried to pass legislation that would essentially legislatively codify what a 6-3 majority in Bostock, codified from the bench, if you want to borrow Alito's language. And Congress has failed to do that. Now, look, we can talk about whether this is a good idea, whether this is a bad idea, whether there actually are religious liberty concerns. But how I interpret lowercase r republic and lowercase r republicanism as necessarily being rooted in consent of the governed and not the supremacy, but the primacy, if you will, of enacting legislative change, as Scalia said over and over again, of enacting societal change through our elected representatives. It seems to me that the judiciary stepping in to doing what it did at Bostock after Congress repeatedly failed to do so is actually very similar to what President Obama did in his Daca and Daca amnesties by also stepping in with executive action after Congress repeatedly failed to do so. I don't think either of those actions can be reconciled with lowercase r republicanism.
Just 2 quick points. One is, Bostock is a statutory interpretation decision, so it can be overruled by a statutory amendment that basically says, no, there should be a cause of action for discrimination on the basis of sexual orientation or gender identity, and that's the Republic, right? And they can always overturn it if they want to clarify it, just as Congress could amend it to specifically embrace the idea that discrimination against on the basis of sexual orientation and gender identity should be protected under Title VII. So there's nothing wrong with the Republic. I think what's wrong with, and I think this is true across the board, is we have a pretty dysfunctional Congress right now. Second, I promised to give a shout out to Wayne Williams, the former Colorado Secretary of State, who noted in the chat or the question and answer bubble that he was sort of initiator of the sanctions in Colorado for replacing faithless electors, and that he feels vindicated, and I think he has been by the decision in Chiafalo.
Samantha, would you like to weigh in on it?
I don't really have much else to add other than to say that, one of the commentaries I read, I forget which of the cases it was talking about, but it was talking about Congress and how, we've reached a point where Congress basically doesn't want to do anything because they don't want to have to be accountable. And to some degree, they've learned that they can count on the courts to step in where they won't. And so, I think that in that regard, our whole system has sort of been distorted. And I don't have a good prescription for a way back. It's something I think about a lot. I think obviously one way back is just, appointing more judges who really take seriously the separation of powers and the idea that they cannot be legislating from the bench. But I think, this idea that, and I think it speaks to a broader sort of issue in society now, which is something I deal a lot with, in my free speech practice, which is that, people don't want to speak out because they're afraid of being held accountable for their views. And so, we have this, I feel like this lack of, this desire for no accountability is sort of permeating our culture. And I think, the point that someone made, and I wish that I had noted who it was, but, that Congress doesn't want to be accountable to anyone and now realizes it can count on the courts was kind of a profound one.
Agreed. Although I joke, but on Twitter, I'm the senator from East Virginia, so I take exception to some of the anti-Senate and anti-Congress comments. No, I'm just kidding. One of the questions that came into is something that strikes close to home. As someone who works a lot in occupational licensing reform, I do think that I think there's a bit of a role for the courts to play with overturning overly burdensome and unconstitutional regulations on businesses and employees as well. And I think this also goes to a degree to the spirit of the Janus decision. But someone mentioned, does the June medical case imply that the court has more latitude in striking down business regulations if there isn't sufficient reasoning to support them? Without going into the long history, of Lochner and everything, I wasn't sure what people thought of the modern court and potential for intervening there.
I'm skeptical of that, regardless of whether it is a good or a bad thing. Even Clarence Thomas in his magisterial concurrence in McDonald versus Chicago in 2010, which of course incorporated the Heller decision with respect to the states, he dives in and talks about the Privileges and Immunities Clause of the 14th Amendment. He talks about Slaughterhouse. But what I think a lot of people actually forget, and it's such a fabulous writing by Justice Thomas, but even in his McDonald concurrence, he doesn't actually come down on the underlying debate between Kurt Lash and some of the more libertarian-leaning originalists like Randy Barnett, et cetera, as to whether the Privileges or Immunities Clause, as originally understood, incorporated these unenumerated, especially economic rights. So if Justice Thomas is not even willing to overtly go there, maybe Justice Gorsuch would. He actually might be like the only true vote for this, honestly. But I do not think the votes are there, and I would not read much into this from what happened in June Medical.
I do think, and it's interesting, not in terms of June Medical, but just, one theme throughout several of these decisions was this idea that, people need to kind of show their work. We saw that, in the Daca case, and also in the tax return cases that, where there's not enough reasoning, the court might step in. So I just wanted to point out that I think, that sort of broad question of, needing to show a basis for something, is present in a number of the cases that we talked about today.
No, I do agree. I think that is a really interesting point about maybe a little bit less deference to government in certain cases, which is kind of unique. Someone also asked a question about stare decisis, but to reword them a little bit, what do you think the role of stare decisis is playing in the current court? And even, feel free to get into just a little bit the role it ought to play in the court.
Sure. So I'm happy to start. So I think Alan's instincts are, if I understand it correctly, are correct on this, which is that stare decisis is either used or not used depending on exogenous factors that have very little to do with the exact case, which is another way of saying that it's overtly political, which is a theme of my kind of running anti-stare decisis commentary. In a 1998 case called Eastern Enterprises versus Apfel, if I remember correctly, I'm thinking of, scratch that. 1998 case called Montijo versus Louisiana. I'm getting my case confused here. Justice Scalia laid out a 4-factor test for stare decisis. Justice Scalia famously took a slightly more, for lack of a better term, pro-stare decisis view than Justice Thomas, who was always excoriated it. He laid out 4 factors, reliance interest, workability of the precedent, whether the precedent was correctly decided as original matter, et cetera. And those 4 factors, I think, are obviously a little more crisp and more tangible than, for example, the court's invocation of stare decisis in Casey versus Planned Parenthood, a very famous invocation there. But it nonetheless inevitably is open to judicial malfeasance. And it is so easy to distort this. And one example that I always give of this is that many of the justices who are in the plurality in Casey versus Planned Parenthood were also in the majority in Lawrence versus Texas. And I'm not going to get into the actual law of Lawrence versus Texas, but it overturned a 17-year-old precedent, Bauer versus Hardwick. So you really just can't have it both ways. I think we see that on the current court repeatedly. It seems to me like as a general rule, especially looking back to the 2019 case of Hyatt versus Franchise Tax Board, that the progressive justices are moving in a more pro-stare decisis direction, whereas the conservative justices tend to be a little more all over the map on this one. But my general criticism of stare decisis, holding aside my criticisms of it as an original and textual matter, is that as a pragmatic and consequentialist matter, I have yet to see a stare decisis test that is not open to naked political manipulation.
Well, and I think that to some degree, the reliance on them, or maybe I would even say obsession with stare decisis, stems from the fact that the court is now, adjudicating so many questions that really are legislative questions. And, because I often think about this, I have this whole spiel I always try to give about how, it's really, I think our whole political process has just been so skewed by the fact that the court, is really, and I think Bostock is a decision like this, is really fundamentally answering legislative questions. And I understand why people are obsessed with stare decisis, because, for example, if I were, married to a woman, the idea that, one justice could come in and change that and suddenly make my marriage illegal would be terrifying. I mean, I think it speaks to just the dysfunction of having an unelected group of 9 people deciding things that really should be decided by the legislature, because within the context of that, I understand why people will go to the mat, will do everything to try to protect these rights, because, they're controlled by a process in which they don't have a voice, not a legislative process. So I think in that context, the need for stare decisis makes a lot of sense, but it's sort of built on what I think is really a very, very faulty premise. So that's not really an answer, just as much as some thoughts.
Just really quickly, because I know we're running out of time. I would say I agree with Josh that it's I would call it indeterminate as opposed to manipulable, because anytime you have a multi-factor test, I mean, you're going to get judges from with different political valences weighing those factors differently. And so I don't think there's necessarily a principled, I haven't seen a sort of foolproof way to sort of analyze when stare decisis should be not adhered to either. And so I'm not sure that I'm confident that the court will come up with one. In terms of what the role is playing on the current court is that I think that, notwithstanding my comment about Janice, I think Chief Justice Roberts is using it as sort of a mooring to keep the court from getting too ahead of itself, and that goes back to the, I think, acknowledged institutionalist Chief Justice Roberts that he is sort of seems to really be, and so he's going to also use it in a different way. He's going to manipulate it in a way that, well, this decision is not going to make us look too radical, and this one is, and I think that's how he's using it effectively.
No, thank you so much to all our panelists. We're just about out of time, but I really enjoyed this discussion, and I'm glad that we had 3 panelists with very different views on. So thank you so much, and thank you for having me as your moderator.
Absolutely. Thank you so much, Shoshana. So I wanted to say thank you again to all of our panelists and, of course, our moderator, Shoshana, Assistant Attorney General Williams. It's been a wonderful discussion today, and I'm very excited that we had such divergent viewpoints. That's what makes these events interesting. Our next event, please put it on your calendar, will be September 15th with Doug Benevento from the Environmental Protection Agency. We're looking forward to seeing you all again on a future Zoom during these unique times. And of course, someday in the future, we will meet again in person. And again, I just want to thank everyone one last time. And with that, we're going to close the meeting. Thank you.